Thank you.
SJC-11334, Franklin Office Park Realty versus Mass Department of Environmental
Good morning, Counsel.
Good morning, Your Honors. Assistant Attorney General Lou Dundon for the Massachusetts Department of Environmental Protection. May it please the Court. The language at issue in this case is the willful and not the result of error precondition in Chapter 21A, Section 16, which DEP interprets to capture violations that meet two separate legal prongs. First, that the violator acts willfully, meaning intended to perform the underlying action that amounts to the violation, and second, that the violation of law was accidental, unforeseeable, or beyond one's control, which is a negligence-like standard.
And that has to be seen, though, in context of what the point of it is, and that is to excuse the DEP from giving notice. And the point of the notice is to give the purported offender an opportunity to cure before imposing a penalty for not doing what should have been done.
It's true the statute sets up an either-or situation where either DEP gives notice or, if one of these preconditions applies, they can impose a penalty without notice.
And so, yes, because I'm very curious about why it is that this requirement that notice be given somehow is at odds with the statutory purpose, or as you argue, that would require the Attorney General to have to prosecute. I don't really understand the policy arguments that you're making about why the judge's view makes no sense, because I see this as all being in the context of whether or not you give notice and an opportunity to cure, not whether or not you bring an action against somebody.
I think you have to look at the context in which the statute was enacted and what the legislature was trying to do. At the time of the enactment, Your Honor, we had a situation where DEP's options were either to issue an order for someone to come into compliance or refer a case to the Attorney General's office, and that simply was not working. That's the reason why the statute was put into place. There was not significant deterrence being had, and the types of violations that were not being deterred were the sort of bulk of violations that didn't rise to the level of being referred to the Attorney General's office, but were still causing harm. We're still failing to provide deterrence, and those are violations most problematically that are uncurable, which are like the violations in this case. Here,
But he did cure them.
Here, Franklin Office Park violations included failing to notify DEP that the asbestos work was going to happen and failing to package them, which means the Franklin Office Park exposed the public, the environment, and its own employees to a risk of mesothelioma from asbestos and exposed the public to asbestos in general.
I take it that just on these facts, would this be right that if one of the violations you claim is the failure to give notice, if the notice had been given and this had been done properly at the beginning as opposed to curing, I mean, yes, the bulk of the stuff gets wrapped properly and disposed of properly, but your argument is that you haven't, there's asbestos fibers that could be circulating in the air nonetheless. I mean, so after the fact cure isn't nearly as good. Is that part of it?
That it entirely undermines the purpose of the underlying statutes. DEP's job is to prevent harm to public and the environment. So the point of this statute is to give DEP the tools to enforce those statutes. And when the result of these violations is to actually expose the public to the harm that we're trying to protect against, there's no order that can cure that. There's nothing DEP can order them to do to undo the fact they've exposed the public and their employees to these fibers.
Well, I mean, if it had been at a different point, you know, and it was if the owner of the property had ignored information that was coming from the first hauler that had taken them away and said, wait a minute, we've discovered that this is asbestos, then they tell the owner that, and the owner then immediately takes steps to make sure it's properly disposed of. Isn't that a kind of cure?
I'm not suggesting no violations can be cured. I'm suggesting that there are a great many of them that cannot be cured, including some of the ones in this case, and that's the reason why the statute was enacted in the first instance.
Well, the focus has already been noted, is that it's a notice requirement. And so I'm trying to understand, and reading the whole thing, the first one of these is for noncompliance. It sounds pretty serious. Pattern of noncompliance, right? That's really bad. But when you look at how you establish a pattern of noncompliance, it says you failed to, you've previously been notified and on 2 occasions you didn't comply. After that, how do you ever get to that very serious one if you really never come to the point of actually having to give anybody notice? How do you even get to serious noncompliance? Because you kind of skip that point. You say, well, not really. It's just as long as you do it. And we don't really have to give notice, so we don't give notice.
Well, first of all, I'd note that in that precondition, one of the other types of ways you can have a pattern of noncompliance is one violation that you fail to respond to. So, in fact, the basic notice provision would fall under that example.
I'm sorry? You can do it once and that's a pattern?
I believe under the statutory language that the legislature enacted, one way to prove a pattern of noncompliance is that you have in the past been given notice and you have not complied with it. So the general notice situation actually falls into that exception. But I think the larger point is one of the biggest problems with Franklin Office Parks and the Superior Court's interpretation here is they entirely ignore that second prong that I was talking about in the first instance. And I think Your Honor just described it in sort of the way the Superior Court did, which is everything falls into this violation. But that's not the case. The way the violation is applied is if you intend to do the underlying thing, you might be within the scope of the exception. But if your actions were non-negligent, if you took account of reasonably foreseeable information and did reasonable due diligence, you are not within the scope of this violation. And I think that the court below has entirely ignored the limiting principle to this exception, which is why it seems so broad when it is really not an application.
So you're saying that because on the facts here, the examiner basically, the hearing officer said that given the widespread experience that this particular property owner had with real property, and the different people that were employed and so forth, whether he actually knew that these shingles had asbestos or he should have known. Are you saying that that would be, it meets the criteria in this case, but if, for example, it was just a homeowner who had no reason to know that shingles might contain asbestos, is that a different situation?
I think that's the holding that the hearing officer made here. I think they apply the negligence standard equally to everyone, whether it's the people in this case or the homeowner on the roof that you're suggesting, and it will depend on the totality of circumstances in that case whether or not the person acted negligently. Here, we had enough evidence 3 times over to show that these people acted negligently in the sense that you had the knowledge of the subcontractor, F&G, you had the knowledge of Orton, the project manager, and you had the knowledge of me. And we don't have to reach every case, but certainly on the facts of this case, there was far more than enough to show that these people were on notice and should have taken reasonably foreseeable precautions here.
Can I, in terms of the fine, so it's $18,000, something like that. If instead of what happened here, that is when Meehan got notice from the NER that this has got asbestos in it, and immediately cured it, if you will, if he hadn't done that, could the fine have been higher? I don't know how the dollar amount is set.
DEP's enforcement policy talks a little about how DEP enforces that, but yes, they can take consideration of all the facts of the situation, including whether or not people act in good faith once they're notified. And it's true, in this case, he did come into compliance quickly when it happened, and the fine was $18,000 for 4 different violations, and on the grand scale of violations, that's not the highest violation, or highest penalty.
And the DEP could have, if he said tough luck,
the penalty would have been higher, Your Honor. Yes.
So as I understand this, willful, in your view, just means intentional, an act that actually the person did.
That is correct, yes.
But willful means they did it.
Non-accidental, yes. I think that's the way it's described in the case law.
Intended to dispose of something, right?
Correct. That would be an example, yes, Your Honor.
Okay. And the result of, and not the result of error means that if I didn't know, that would be error, but only if I didn't have reason to know?
If it wasn't foreseeable for you to figure out that rules applied and chose not to do them. These are strict liability statutes, and we depend on people to educate themselves about dangerous substances if they're going to choose to deal with them.
If that's what I wanted to ask you, when these administrative penalties were enacted and the regulations formed, and there was that special procedure of going to the committee that needed to do that, was one of the things that I don't know from the record whether it shows this, but is there anything about the rationale was exactly what you just said, that it's an incentive to educate yourself, that you really you cannot, you need, if you really should have known, you know, if you are, for example, here, a licensed construction supervisor charged with knowing the environmental laws, then you're not going to get out of this by just saying, I just didn't know, right? I just wonder whether part of the discussion or part of the record of developing these regulations included a purpose of giving an incentive to people to learn the laws that they should know.
Well, what we have from the legislative and non-legislative documents at the time are letters from legislatures that talk about the problems, you know, what their intent was in the statute in the sense of dealing with the lack of enforcement and deterrence of violations at the time. We have an article written by a member of the advisory board, the legislature's advisory board, which is the MCLE article that I cited, who discusses the history at the time and the intent and spends a lot of time talking about what was intended and what they expect, how they expected it to work. From the actual documents produced by the legislature, all we have is a letter from DEP to the legislature responding to the requirement to pre-submit the regulations. Those did not include the definition of willfulness in that, but it specifically noted that they would develop it with the legislature's advisory board going forward. It then went forward for 26 years, and the legislature amended the statute 4 times, and not only did not reduce DEP's ability to use these exceptions, they gave DEP 3 more exceptions over the next 26 years, which would be an odd thing to do if the legislature thought that DEP was interpreting its exceptions.
But you never promulgated a regulation interpreting this, right? This is all statutory. These are all decision-made interpretations.
That's true. It was decisions made.
There was no conversation around a regulation in the context of the promulgation of a regulation.
No, it was only the context of the promulgation or the creation of the policy document that states it, which was done with the input of the legislature's advisory committee, their delegates.
Now pragmatically, at some point, I gather, DEP has to decide whether to give a notice of noncompliance or whether to give an FAN. Correct?
That's correct.
Do they have the ability, or are they entitled to interview the purported polluter before they do that? Is there any ability to depose that person before they make that decision?
Well, DEP typically doesn't issue these documents on the spot, other than perhaps an emergency order to fix a dangerous situation. These are documents that are issued after the fact, after there's been some discussion, usually, and perhaps some investigation. So they do take account of those sorts of things. And I'd note, I should have mentioned earlier, that we can look to see how DEP has interpreted this. We don't have to guess as to how this has been applied over the past 26 years. The most recent statistics show that DEP, since between 2005 and 2009, has issued 3 times more notices of noncompliance and penalties. So as a practical matter, the exception is not swallowing the rule. And
Okay, but I guess that's not my question. To what extent are you entitled to know the state of knowledge of the purported polluter before you make the decision of whether to issue an FAN as opposed to a notice?
I think that because DEP, to establish this precondition, has to show that it was reasonably foreseeable, they have to have some sense of what the person's knowledge is in the way you're describing it, thank you, Your Honor. So sometimes I can imagine situations on site where it would be pretty obvious that they had knowledge they were in violation of the law, and others where they might need to have more of a discussion that you're describing to figure that out.
So you're saying the reasonable foreseeability relates to their knowledge of the law?
It's whether it's reasonably foreseeable that their action was a violation of law, yes. Whether it was reasonably foreseeable to discover that there are regulations that apply to what they're doing that they can follow.
So that's essentially a should have known standard?
Exactly, Your Honor. A negligence type standard, not a should have known standard. Well, yes, negligence standard.
But should have known what? Should have known the law, or should have known that the shingles contained asbestos?
Could be both in this case, Your Honor. If they knew that they knew that they were replacing shingles, they all had great experience in dealing with shingles, and they all should have known that shingles commonly contain asbestos.
And that's enough. And as far as you're concerned, that's enough. They don't have to know that the law required them to remove it.
Well,
that's right. They don't have to, because they could have, had they exercised due diligence, they could have figured that out, and we expect people to do that.
So they could have exercised due diligence both to figure out that asbestos was in the shingles and then to figure out what the law was.
That's correct, Your Honor.
Well, or at least that if asbestos is in the shingles, it may well be regulated. Whatever. So you needed to go find out what the law was.
Yes, the asbestos context is particularly applicable to the willfulness situation, because asbestos is an ultra-hazardous material, and we expect people to have some sense of that. I think and the reasonable person would have some sense of that.
At least in this particular
industry
configuration of people.
Certainly on these facts, yes, Your Honor.
So you're then saying that the judge erred in finding in view of the evidence that there was not substantial evidence that this person should have known.
The judge didn't actually find that there wasn't substantial evidence that they should have known. The judge only found that there was not substantial evidence that they actually did know. The judge said the should have known requirement is irrelevant under his new standard. And it's actually not clear why that's the case, given he says that there's a duty to investigate. It's unclear how the judge applied that. But the judge left alone the finding that they should have known.
All right, thank you, sir.
Thank you, Your Honors.
Good morning, Your Honors. My name is Paul White from the law firm of Sugarman Rogers, and I represent the appellee Franklin Office Park. I think the appropriate place to start is with some facts that are undisputed, and then an admission that my brother has just made. So there are four very simple facts that I think the court should be aware of. The first is that the DEP concedes, and it conceded before the Superior Court, that there is no evidence that Franklin Office Park or its president, Mr. Meehan, had any knowledge of the applicable legal requirements. The DEP concedes that there is no evidence that Franklin Office Park intended to violate the law. It is undisputed that once Mr. Meehan was made aware, once Franklin Office Park was made aware of this problem, that the shingles contained asbestos, he immediately acted appropriately in dealing with that problem. So that what we have was a situation where at this point the shingles had been placed into a container, had been taken down to a local dump, and upon notification to the DEP from the dump, Mr. Meehan, receiving word that the shingles had been tested, immediately dealt with that problem so that the asbestos shingles were appropriately handled. And my brother conceded, make sure I have it right, that Mr. Meehan did come into compliance quickly.
Can I
So there was
ask
a
you
discussion.
about this? I don't know the extent to which, we have Franklin Office Park and Meehan, including or not including his, I forget his name, but he's sort of the construction manager, the man that he is.
Mr. Orton.
Where it seemed to me that the hearing officer was on pretty solid ground in thinking that in order to be credentialed as he is, he had to know about the applicable legal requirements. And to what extent Franklin Office Park bound by his knowledge?
Bound by the knowledge of Mr. Orton?
Mm-hmm.
Well, what I
its
think
employee?
at most what the hearing officer would have been concluding was that, in his opinion, he should have known of the applicable legal requirements, but there was no evidence that he actually did know, and the DEP conceded before the Superior Court that there was no evidence that Franklin Office Park had knowledge of the applicable legal requirements.
But are we taking that man as part of Franklin Office Park or not?
I don't think that this court is required to do that at all.
Why not? I mean, he's its employee. He's actually quite high up. Why shouldn't Franklin Office Park be bound by him?
He was actually not, Your Honor. He was not an employee of Franklin Office Park. He was the
Mr. Orton?
an employee, yes, of the management company, I believe.
Okay.
Now, is should have known enough?
It is not enough, Your Honor, and I think to answer that question, it is important to understand what the statute is that we are dealing with and why the DEP is being given the power that it is being given. We are dealing with a statute that empowers the DEP to issue civil penalties in certain limited circumstances. This is not the only statute that determines whether or not an entity can be penalized for violating environmental law. Quite the opposite. The DEP always has the option, and still has the option, of bringing enforcement proceedings through the Attorney General. What this provision is about, is saying, let us, this is what the legislature is intending to do, is saying we will give limited power to the DEP to write traffic tickets in a very limited set of circumstances.
Traffic tickets that arguably may affect the public health and safety.
Well, that may be so, Your Honor, but they are nevertheless, this is nevertheless a fine that is being issued without an opportunity to contest the evidence, and only to contest the evidence thereafter, so that the circumstances in which they can do that, the legislature clearly spells out, and it says, so the first place to look at what the intent of the legislature was is the words of the statute. And those are very clear. The statute says that the department may assess a civil administrative penalty on a person who fails to comply with any provision of any regulation, order, license, or approval issued by the department, provided, however, that such noncompliance occurred after the department had given such person written notice of such noncompliance.
And there's a second sentence, right?
I'm sorry, Your Honor?
Right after that is the sentence that says, but in these circumstances, you don't have to give the notice.
Yes, Your Honor. So there are exceptions to that rule. So, and those exceptions necessarily must be read in the context of the general rule, which was that what the legislature was concerned about is people who have been given notice that they are in noncompliance and then do not take any opportunity or take advantage of their opportunity to correct their noncompliance. And so the willfulness exception needs to be read entirely in connection with what the legislature was concerned about.
Mr. White, I don't want to interrupt you, but I want to make sure I've got these. You said you started by saying there were 4 facts, but you only got to 3 of them. What's the 4th one?
I did, Your Honor. The 4th fact that I was concerned about was that the DEP concedes that there was no written notice of noncompliance, that very first general rule that I just was referring to. The DEP had the option of doing what the legislation says, which is sending a notice of noncompliance and giving the violator. These are all notices that are going to violators. Everybody who receives one of these notices, it's assumed, is in violation. The question is whether or not the DEP should have the power to issue a civil penalty.
Now, would notice be necessary when you're dealing with people who are very aware of the substance they're working with and wouldn't really need to be warned?
The issue there, Your Honor, would become whether or not that person is a willful violator. That's really the question, whether or not such a person knows that they are in violation. Because you're absolutely right, what the legislature is concerned about here is making sure that before we issue a civil penalty, before we give the DEP the power to issue civil penalties, we only want those penalties to be issued to people who know that they are violating the law. And
is that know that they're violating the law, or in this case, know that they're dealing with a hazardous substance?
Know that they are in violation of the law. And those are exactly the words that the legislation uses. It says a person who fails to comply with any provision, and after such noncompliance, after a reasonable time, has elapsed for coming into compliance. So,
isn't this an invitation, though, to willful blindness?
I'm sorry, Your Honor.
I mean, it seems to me your interpretation encourages people not to know what the law requires.
Well, the law, those are the words of the statute, Your Honor. The statute makes clear that if it is no excuse. If you have violated the law, you are in violation of the law, and the DEP has the power to bring proceedings against you. The issue in this statute is whether or not the DEP should be allowed to simply issue a civil penalty or not. And what the legislation is saying is, we will give the DEP this extraordinary power. We are talking about an extraordinary power here that is being given to an agency, but it must exercise that power in limited circumstances. And we don't want citizens to be confronted with getting an $18,000 traffic ticket, because that really is what this is. It is simply a notice that you receive that says, please pay us $18,000, unless we know for sure that that person knows he is violating the law. So, tell him you are violating the law, give him an opportunity to come into compliance. My brother conceded, and it is undisputed, that this entity came into compliance immediately.
Could I ask a question there? If that hadn't, at that point, I think I understood Mr. Dundon to say, the penalties escalate rapidly, so that the concern about getting away with it isn't there unless it's there even if you get notice, right? Well, if you don't get notice at this point, right? If they didn't do that, what are the penalties?
I think the issue here, Your Honor, that I think Your Honor is addressing is what is the impact? What is the public policy behind this? Which is that it could well be the case.
As reflected in the statute.
I think what is reflected in the statute is let's give the person an opportunity to immediately stop doing whatever they're doing.
And if they don't, what's the penalty?
By knowing what the law is, and if they don't do something about it.
How severe is it if they don't?
I'm sorry, Your Honor?
How severe is the penalty if they don't? There's something at the bottom here about $25,000 a day, but I don't know if that applies here.
I don't know the details of that, Your Honor. So that is so what I'm suggesting is that is very clearly the statutory scheme here, which is that while it may well be the case.
If that's the case, if willful means you commit an act knowing it's in violation of the law, then what does the next phrase mean, and not the result of error? That's a second requirement. How could one commit an act knowing it's in violation of the law, but yet not be responsible or not be entitled to an FAN because it's not the result of error?
I think it's the opposite, Your Honor, which is that what the legislation is concerned about is making sure that people who are getting a civil penalty know very well that they are violating the law and that they haven't just made a mistake. If they've just made a mistake, then they shouldn't be being penalized with a civil penalty.
So you're saying that that's not surplusage, but that's saying the same thing twice?
It is underscoring what the intent of the word willful is, which is that it is absolutely not what my brother says, and that's a very simple interpretation of the word error, is just to say it's not a mistake. There is nowhere in this statute that gives rise to the interpretation that my brother offered, that the words "and not the result of error" means negligent conduct. The legislators know very well how to say negligent conduct. It would just say, if you've committed negligent conduct in causing a violation, you can be penalized with a civil penalty. The word negligence is nowhere in this statute at all. So
now, going back to Justice Botsford's question, wouldn't it mean that if somebody is blissfully ignorant, they would be spared a civil penalty and be given a second chance, but somebody who is not blissfully ignorant would not have the benefit of a second chance?
I think that is what it would mean, Your Honor, because that's what the word willful, clearly in its traditional sense, and this is clearly what the traditional sense of the word is intended, is just that. This is a willful violation. And those cases, if I can just add this, Your Honor, those cases that my brother relies on about where willful means merely volitional conduct, if you look at the cases that he cites, and they're in his brief, I believe, in a footnote at page 16 of his brief, they all are criminal cases that deal with a description of the actual underlying conduct, but not of whether or not a violation is willful or not. So it may be an adjective like, and there are several of them, a willful discharge, a willful abandonment. And in those contexts, it has been recognized that the legislature, when it uses the word willful, is meaning deliberate, intentional. But nothing could be further from those words. When you look at the words in this statute, it talks very clearly about a willful decision, a willful violation of whatever those underlying, I read the list of them, but whatever those underlying regulations, orders, licenses, or approvals are. The issue is whether or not the violation of them was willful and not the result of error.
Is the issue here that your client didn't know that the shingles contained asbestos, so they were not aware of the operative facts that would have triggered the law? Or that they didn't know that there was the legal regime as to how to properly dispose of it?
It is both of those things, Your Honor. So there is no evidence, we say, that they had actual knowledge of the existence of asbestos in the shingles.
Assume
And the
they,
most
had
that-
assume they had actual knowledge, but disposed of it. They had actual knowledge that,
That would
the
still not
asbestos
be thank you, Your Honor.
contained,
Yep.
the shingles contains asbestos and disposed of them, but we're not aware of the law.
That would still not, correct, Your Honor, that would still not be enough. So that there is indeed an issue here, and the Superior Court quite properly addressed both of those issues. The Superior Court said that there is no evidence of any actual knowledge of shingles, that the standard should have known is an
No evidence
inapplicable
of
standard.
hazardous substance, no evidence of the operative facts that would have triggered the legal consequence.
Correct, and no evidence whatsoever, and it was undisputed that Franklin Office Park or Mr. Meehan knew that there was any violation of the law that was taking place. So this is a requirement that there be a willful violation. That's what willful means, and there clearly was not any level of knowledge that gave rise to a willful violation.
Thank you, counsel.
Thank you, Your Honors.